I'm going to talk about sentencing in the Magistrates' Court for military personnel convicted of offences relating to driving under the influence. This is my second video specifically on this subject. In my previous video, I spoke about the Magistrates' Court sentencing guidelines and Major AGAI 67. In this video, I want to talk specifically about mitigation. Mitigation is what can be said to a magistrate's court prior to sentencing to try to make the sentence less severe than may otherwise be the case. In my previous video, I explained that the sentences available to the magistrate's court depend upon the level of intoxication. And the point is that the sentencing guidelines are exactly that. They are guidelines. It is possible for the magistrates to go outside of those guidelines, provided that they give reasons. So the level of intoxication directly relates to the sentence. A sentence relating to intoxication of between 36 micrograms of alcohol and 89 micrograms of alcohol in 100 millilitres of breath will usually be a fine. The starting point will usually be a fine. Between 90 micrograms of alcohol and 119 micrograms of alcohol, the starting point is a community order. And anything over 120 micrograms of alcohol in 100 millilitres of breath, the starting point is custody. Now, applying that to Major AGAI 67, clearly a conviction that results in a custodial sentence is going to result in termination of service under Major AGAI 67. And applying the Major AGAI 67 rules that I mentioned in a previous video, anything else is likely to result, for anybody who is retained, in a reduction in rank, or if they are a private soldier, in marking time in their current rank. But discounting for now anything over 120 micrograms of alcohol and 100 millilitres of breath, which will normally result as a starting point in a custodial sentence of 12 weeks or more, the key point seems to be anything over 90 micrograms of alcohol in 100 millilitres of breath. And if a service person is around about that level, around about the level whereby a magistrate's court may start at a community order or may choose to go down to a fine, it seems to me that that is the most important area at which to present mitigation, to try to argue that a fine is more suitable than a community order. And for military personnel, there are a number of matters that could be put forward to try to persuade a magistrate's bench to adopt a fine, to impose a fine, rather than to impose a community order. The first point would be to address the issue of Major AGAI 67 and the likely reduction in rank, because a reduction in rank is going to have an effect on salary, and as I explained in the previous video, fines are defined relevant to an individual's relevant weekly income. So if the relevant weekly income is going to drop as a result of the Major AGAI 67, as a result in turn of the conviction, then that is a matter that can be put across to the magistrates. Another matter that might be put across to the magistrates is the effect of a driving disqualification on deployability, particularly for individuals whose work involves driving vehicles. Or, for example, individuals in the Royal Military Police who may have to consider recap badging because their position within the Royal Military Police remains untenable as a result of their conviction for driving under the influence. Other areas of mitigation to put to the bench might include personal mitigation, family circumstances, and of course if an individual has good SGRs, they might also be handed up to the bench in advance to demonstrate an individual's otherwise good character. The point behind all of this, for an individual in or around about 90 micrograms of alcohol in 100 millilitres of breath, is to see whether the court can be persuaded to go outside of the magistrate's court sentencing guidance and to consider imposing a fine rather than a community order. Another area to address to the magistrates would be the effect, for example, of guard duty if an individual is given a community order. If they're given a community order, and assuming that is going to have to be worked through on a weekend, that will have an effect on other people within the unit if the individual has to then go off to work with the National Probation Service. So it can be argued to the magistrates that imposing a community order will punish people completely unconnected with the matter. It will mean that people otherwise completely uninvolved in the matter will have to step up and take over, for example, guard duties or other duties within the unit in order for the defendant to attend appointments with the National Probation Service. And it might be that a sympathetic bench in those circumstances would agree to consider imposing a fine rather than a community order. So in summary, applying the Magistrates' Court sentencing guidelines and applying Major AGAI 67, an individual who is convicted, either by pleading guilty or being convicted of driving under the influence, is likely to face reduction in rank, applying Major AGAI 67. That will have an impact on their relevant weekly income, and that in turn can be a point argued to the magistrates in order to see whether it will be possible for a fine to be imposed rather than a community order. Other areas to consider will be the effect on other people in the unit if the individual is expected then to go and make appointments with the National Probation Service, because it means they won't then be able to fulfil duties that other people then have to take. And bear in mind also that if an individual is reduced in rank, then those duties will be commensurate with the duties of the people within that rank. So all of those matters need to be explained to magistrates, need to be put forward to magistrates in anticipation or in hope that the magistrates can be persuaded to impose a less serious, less onerous sentence than may otherwise be the case.